So, we'll discuss the 15th problem. The plaintiff contracted dermatitis, a kind of skin disease, as the result of wearing a woolen garment which, when purchased from the retailers, was in defective condition owing to excess sulfides negligently left in the garment during the very process of manufacturing. Advised the plaintiff as to his rights. So the problem is based on the strict liability of a manufacturer. The facts of the problem are similar to those of the leading case, Grant versus Australian Knitting Mills Limited, 1936. In this case, the presence of the deleterious chemical excess of sulfurs was hidden, a latent defect, and could not be detected by any examination that could reasonably be made. The garment was made by the manufacturer for the purpose of being worn exactly as it was worn in fact by the plaintiff. Therefore, it was held that there was a duty to take care as between the manufacturers and the plaintiff, for the breach of which the manufacturers were liable. Therefore, the plaintiff is entitled for damages. And now we'll go to the 16th problem. And it is a taxi driver that is taxi negligently and without looking where he was going, ran into a child who was on a tricycle behind him, slightly injuring him. The child's mother was in her house 70 or 80 yards away, heard him scream and looking out of the window saw the taxi back into the tricycle but could not see the child. She suffered a shock and fell ill. Discuss the taxi driver's liability to her. The facts of the problem are similar to those of the case of King versus Phillips, which was decided in 1952 in the case in action by her for damages for the shock thus suffered by her. It was held that of the negligence vis-a-vis the mother was whether the taxi driver could reasonably have foreseen the risks of damage to her, that the taxi driver would reasonably have contemplated that if he backed his taxi cab without looking where he was going, he might cause to the mother the injury complained of, and that therefore he owed her no duty of care, and her claim should be dismissed. Thus, in the present case, the taxi driver owes no duty to her, and her claim should be dismissed. And now we'll go to the 17th problem. While the plaintiff's motor car was being driven along a highway, the driver saw in front of him a number of ships unattended. He applied the brakes, but immediately a ship jumped from the back of the rear side and ran in front of the car and broke the steering gear, in consequence of which the driver lost control and the car ran into the bank and was damaged. Discuss the liability, the owner of the ship, the facts of the problem is similar to the case, that is the leading case, his Garage Limited versus House in 1926, decided by the King's Bench. In this case, while the plaintiff's motor car was being driven along a highway, the driver saw in front of him a number of sheep unattended. He put on his brakes, but immediately a ship jumped from the bank on the rear side and ran in front of the car and broke the steering gear, in consequence of which the driver lost control of the car and the car ran into the bank and was damaged. It was held that the defendant was under no duty to the plaintiff to keep his ship from straying upon the highway. Therefore, in the light of authority of the above case, the defendant, the owner of the ship, is not liable.